My name is Jeff Morgan. I'm out here at New Beginnings Church out in Bedford, Texas with my good friend Arnold Yan. Arnold, it's so good to see you once again.
Yeah, good to see you, Jeff.
So Arnold has been fighting a number of things in these corrupt Tarrant County courts, and not too long ago I got to sit in on one of the hearings with him. But Arnold, I want you to bring us up to date on a couple of the things that you're doing, your Rico case, for example, other things that you're finding out about these courts. We want to support you completely in this. So tell us a little bit about what's been going on. Why don't you start with the Rico case?
Yes, I want to bring people's attention for the Rico case right now because we are all litigants in Texas, and we all knows we don't know the law. Only the lawyers know the law. But what if the lawyer and the judge twist the law and they never tell us what the true law is, and they use that to take advantage to get money from people's pocket and enrich themselves? This is what I find out from my case. I've told Jeff many times the major merits of my case is not about my own family court case, is about the crime in the court. They are using the court as a platform to stealing money from American middle class's pocket. And after I exposed that, I caught them, I exposed that, the whole system right now is working together to try to cover up the crime, because that is a Rico crime decades around statewide, and none of the American people has the knowledge to know that, and they try to conceal that without being exposed. And they have been doing that for many years. The whole thing is, people, you guys should pay attention. There's a statute called 18 USC 664, which is one of the RICO Act defined in federal RICO statute. Federal RICO statute defined about 39 acts. The people probably have the well knowledge about the weapons smuggling or drug dealer, or the robbery in the bank, all this kind of violence crime we all know, and maybe this a part of the cartel work is a RICO. But there's also white collar crime defined as a RICO act, and our DA never prosecute white collar crime defined in the RICO Act committed by the lawyers. So 18 USC 664 clearly said anyone unlawfully extract the money from people's pension fund, that's a RICO Act. They have been issuing court order to extract the money from our middle class pension fund for decades statewide. So that is the fact has been there. I don't need to prove if they have done that. They've done that to millions of people in Texas. The only element I need to prove is this is unlawfully doing so. And the statute is very clear. If you extract the money from pension fund, you don't have to use for yourself. It can be for your own use or other people's use. So basically, as long as the money get unlawfully extracted from the pension fund, that's one of the RICO Act. So the unlawful element is very clear. Texas Family Code statute is very clear. You cannot extract money, get money out of through QDRO. They call qualified domestic relation order.
The quadros.
The quadros before the divorce. The statute is clear, and also Texas Supreme Court has a ruling say, based on the statute, there's no jurisdiction to issue temporary order for a QDRO. It has to be a final judgment, post-divorce trial judgment. But right now in Texas court, I have found out there's thousands case they are issuing temporary order to getting money from people's retirement fund. Do you know why? Because all the trial gonna last for 3 years, 5 years. The lawyer has no patience to wait to put their hands in your pocket. They want to get it right now immediately. So they are asking the court to issue in temporary interlocutory order so they get extra money from 401k pension fund, which is completely unlawful because there are no statute permitted in doing that. Once I caught them doing so, the whole court system, judge, lawyer, the state of Texas, and even the system, DA office is trying to shut me up and try to conceal this crime, because all of them has been working together try to conceal this RICO crime. That makes them become a RICO conspirator. The RICO conspirator is different than our normal understanding as a criminal conspirator. Criminal conspirator, you have to participate to the act that they commit crime. RICO conspirator, according to the federal statute, is very clear. Any damage control, concealment, or if you know that, you don't report that, that is part of the RICO conspiracy. So if you have the knowledge of RICO crime, you don't report, you do damage control, you try to shut up, and that's RICO conspiracy. This is defined in the federal statute. Now we have the whole state of Texas actor in the DA office, in the state of Texas, and trying to work on committed the crime of 18 USC 64,000 times, and they all work together try to conceal the crime. So this is the message I left to the public, and a lot of people warning me I'm gonna be watch my back, I'm gonna be careful of my safety, but I say for the Texas people, I'm willing to sacrifice myself. If one day I'm no longer live in this world, I have left enough materials, all my filing is I put on the public domains with all the order I exposed to that. Right now, trust me, even the federal judge, or in Fort Worth, in Texas, they try to shut me up because they don't want this one to be exposed. So my federal case was just dismissed by the federal judge about a month ago. I'm in the middle of the appeal. The most concealing conspiracy part of this ruling is, in the whole rulings, the federal judge, yes, a very corrupt federal judge, he ruled that I'm a crazy guy. I sued the state of Texas and the judge and the lawyer for money laundering. The funny part is, on the whole pleading, I never even used the words money laundering. Money laundering is Rico Act 18 USC 1556. I sued for 664. There's no one single words in my pleading I sued for 1556. So he just ruled to say, I have no ground to sue everybody for money laundering because I have no facts, so he dismissed my case. In the whole ruling, he never mentioned about the true pleading I allegated, which is 18 USC 64, stealing money unlawfully from pension fund. Yes, I have a case in the federal court, North District. Pay attention on that. Keep yourself updated on progress. I want everybody, whoever encountered the family court in the past 10 years, 20 years in Texas, go back, look at your order. If you get ordered by a temporary order before the final trial and they ask you to withdraw money from pension fund, that's Rico Act. That's unlawful. There's no statute supporting that. That's my message.
What is the statute of limitations as far as prosecuting them?
Rico Act, the statute of limitation is 10 years. But if they don't tell you, you don't know that the statute of limitation what they call trial. Right? So basically, if the whole state of Texas, the whole state, all the lawyer don't tell you it's illegal, and the law thinks as lawful, and you don't have the knowledge, that statute of limitation we're gonna throw that. So there's no statute of limitation right now. I think I'm the first one bring this message to the Texas citizen. Yes, we have lawyers. They work together. The lawyer dressed in the suit, lawyer dressed in the robes, as acting as a judge. They are stealing American middle classes pension fund. The federal ERISA law said that they are in place to protect our pension fund because this is the society interest. This is the federal interest for the people when they get retired. They can get a pension fund after they retired. Even ourselves, if we get a bankrupt, broken, we cannot get the money from our pension because we can only get that after 60. We have reached the age of 65. Nobody can get that, but the lawyer figured out a way. They use court order, unlawful court order illegally, and they don't tell us because using court order they can get the money out, even it's an illegal one, and if they don't tell you, that becomes the legal one.
So as far as the punishment for this crime, this RICO crime, what is the punishment, the range of punishments that these attorneys and judges and everybody else, the entire state bar, could be subject to?
RICO crimes, the minimum is 10 years if you look at all the past statute, and that's why.
So we could put all the attorneys.
That's true. The whole attorneys, the whole state bar, and the whole judges, whoever issue that, and they work together, and whoever try to cover the up, and as a damage control, and RICO conspiracy, the act of damage control is RICO conspiracy. If you have the knowledge and you don't report that, in the federal common law, the RICO conspiracy is very broad. Even if you talk about that, it's RICO conspiracy.
What you're also saying is too, what I would assume is that this is not just Texas. This is throughout probably the entire United States.
That's true. Probably in the entire United States right now, if you have a statute say you cannot, basically it's against the federal law to get money out before you get a divorce. Nobody can do that. Even I can become like a homeless, I cannot do it. But they are doing that right now. So it meets the unlawful element. Go look at 18 USC 64. Anyone unlawfully, willfully extract the money, embezzle the money from pension fund for own use or any people's use, that's RICO Act. There are only two RICO Act that will meet the RICO conspiracy, the pattern of the RICO Act that will trigger the RICO suit. That's why I really need to worry about my safety, because I have a potential case to bring the awareness of the whole American people. We might need to be able to sink the whole family court system in the United States.
That would be a very good thing. Now, are these documents public, that people can access them if they want to see them?
Yes, my pleading has been posted in court listener website. All my argument has been court listening argument website, and all my pleading, all my argument. I am a pro se litigant. I'm suing 11 party. On the opposing side, I have a 44 years experienced lawyer, which is the former president of State Bar of Texas as opposing counsel arguing with me. I have State Bar of Texas counsel arguing with me. I have the DA office counsel arguing with me. They all assert, they never say they did anything lawful. They never argue this, whatever they ordered in the court order is a lawful. They said, I cannot sue them because they have state immunity. They have the judicial immunity. They don't say they did things right. They say, okay, I can do whatever I want. You just cannot sue us. We have immunity. But I defeated them on 2 of the immunity. The federal judge said, for the Rico actor, the State Bar of Texas has no immunity. He clearly ruled that in the order. And also, if I sue the lawyer for the Rico, and the lawyer has no immunity for the Rico actor, that is confirmed. But he gave the judicial immunity for the judge I sued, which I will appeal to the 5th Circuit right now. And also, he dismissed my case, basically say, I sued the Rico for money laundering, and he dismissed my whole case. He basically twisted my order, tried to help his comrades in the State Bar of Texas.
Yeah, that's interesting that you say that he's ruling against something that you never pled, never sought any type of relief for.
Yeah, it's against the civil law procedure because in the motion to dismiss stage, the federal statute is very clear. You have to assume everything alleged as true. Everything alleged true. We are not in the motion to summary judgment here. In motion to dismiss stage, everything I said has to be true. I showed them the order, I showed them the statute, I showed them the common law. So basically, they have already ruled that to get the money, and I have all the emails between the lawyer colluded together, try to cover up after I caught them. Oh, that's violation. I have all the emails in my pleading. They said we must say that. Otherwise, there's no way we can get around a federal statute. That's what they said. We have to collude to cover the whole thing up. And the order was there, and for the 18 U.S.C. 64 Act crime, and the judge said I sued them for money laundering. You go to my whole pleading. I have 105 pages pleading. The words of money laundering never appeared once in my pleading. That is so funny. That is completely concealment and damage control.
Yeah, and Arnold, one of the things I've appreciated about you, English is not your first language, is it?
It's not my English. I mean, I'm a first generation immigrant. I come to the States about age of 30. I have no U.S. degree, and English was my worst subject when I was in school. So,
but you're an extremely intelligent person, and I mean the stuff that you've done, the things that you've read, the case law that you put into your pleadings has been pretty spectacular, I would say.
Yeah, I mean, if I don't work harder, there's no chance I can defeat the two immunity argument against the State Bar of Texas, and also the opposing counsel, who is a 44 years experienced former president of the State Bar of Texas. So I am like high school kids playing basketball game in a court against 11 party and with Michael Jordan right now, and the referee is not on my side.
Anything else you'd like to add about this?
Oh, I just want to let you know, the things I caught is because we have a very unique system in Texas, because it's unlike any other criminal court or civil court. In the Texas family court, lawyer is the one giving the responsibility of underwriting the order. So judge will render the order in the court. The lawyer is the one putting into the writings and ask the judge to sign that. And the statute is very clear. When you're underwriting an order, you have a ministerial duty and you have no discretion to change the order. But it's very common right now. Lawyer, the whole State Bar of Texas Associate, they use that privilege. They alter the order after the judge ordered that in favor of them. So you basically get a retrial twice before the judge sign that. Everything you ordered become not the same thing you heard from the court. And our due process request what? A notice of hearing, and also a neutral decision maker. Now we are giving the lawyer as a decision maker to enter the order.
The opposing counsel.
Opposing counsel. Let me make it clear. Our family court has subcontracted judicial power to lawyer, so they can put in the order to grant them relief under their own discretion. The State Bar of Texas know that. They are protecting their lawyer to have the privilege to illegally obtain the judicial power to exercise judicial discretion and put things into written, go to the order to take advantage of our litigant. And all lawyers colluded together because they don't care. In today, they give opposing counsel the privilege, and other day they will get a privilege back from the judge. So they all collude together as long as they can maintain the privilege to get this subcontracted constitutional judicial power to adding the relief into the order before judges sign that. They enjoy that. We need to challenge that rule, and because this is how they steal money from our pockets, and they use this privilege. Most of the things they changed, they put over there with their own discretion is to grant them legal fee. They are using that opportunity to illegally take advantage of us to grant them the lawyer attorney fee, which is the business revenue was not heard in the court.
Well, it's more than just the fees too, because in your situation, the opposing counsel has changed the order regarding the possession of your child.
Yes, it's so funny because Jeff Morgan was in my hearing and he personally hear what the judge ordered. The judge gave me 50% of possession time right now, but he gave she gave the 50% possession time. So I'm supposed to be 50-50 possession with my soon-to-be ex for the child right now. This is the court ordered.
And by the way, your soon-to-be ex is not the biological mother of the child. Is that correct?
She's not biological. She's not giving the birth, and they're giving her the custody. So I have to pay the child support fee, and that's a separate subject we're going to cover. But
we'll cover that in a different one. That's another one.
But this one is very significant because when the lawyer drafted the decree, they take the advantage. They revoke the judge's decision. In the small print of decrees, when she definitely say I have 50-50 possession, she said, as long as I don't live in the same district, school district with the kids, I immediately downgrade myself to become a non-custodial parent. That was nothing to do with the judge's decision. Judge's decision was, the mother has some sort of behaving, make her, she concerned about that. So that's why she said she cannot have the primary custody. I got it 50-50.
Right.
Then the lawyer say, okay, if you don't live in the same city and you lose that, oh my gosh, once I sign that, the trigger is already there. The day I sign it, the decree say, this ruling become immediate effective. So if I sign the decree, right now, she know where I live. I don't live in the same district, but I live in about 10 minutes away. And of course, it's because of another illegal order that the court has rendered. Anyway, I'm still in the middle of process. And so the lawyer basically took away my possession, and using the small printer, she put in the decree. That is a very dirty trick. They have been doing that in the court again and again, and they don't consider that's unlawful and illegal, and they have been doing against everyone who cannot read the contract thoroughly. They think I'm a first-generation immigrant. English, I'm not good, so they want to put those small print clause to retrial me by the lawyer.
Yeah, and what took place in that situation was simply atrocious. I know we'll talk about this at another time. We've got to get inside here in just a moment. But just what I saw there, because I came in as an observer, I knew some of the background, and even the judge that, I thought would probably do a good job, she had a lot of ignorance in certain areas. She did think she let crimes go by. She had no idea what about some of the Bank Secrecy Acts, the different provisions within that. And you had some very substantive arguments that got dismissed out the window as if they didn't even exist. And yet, I think that perhaps both your soon-to-be ex-wife's attorney and the judge had a responsibility to report these crimes.
Yeah, right now the court has become a platform to conceal all the crimes because judge has the absolute immunity, so they can play the actor as conceal all the crime, and the DA, they call themselves, they have the prosecutorial immunity, so they are able to conceal any crime they like to conceal to help any parties in the court as long as they can continue to keep this corrupt system established. That's their major role right now. I have a big case going on. I'm going to file another federal RICO allegations in the federal court in next week. I'll keep everyone updated.
Yeah, and you're not going to stop.
I'm not going to stop because I have everything. I don't even need to do discovery. All the evidence I already caught on the paper. It's from the court records. It's there. The only thing they want to conceal, they don't want to hear me. So right now they just closed the court to me, so I cannot make any pleading.
Yeah. Well, Arnold, thank you so much. We've got to get back inside here for the event that we came for. This was completely off the cuff, unscripted, unprepared, but I think you're always prepared.
I'm always ready because I read a lot, and this message is to all the fathers in Father's Day. Go back, check your order. You are a victim, and they didn't tell you.
Thank you so much, Arnold. Great to see you again.
Thank you.
Thanks. Bye now.